We are now live and on the record. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much and good morning and welcome to today's remote sitting by the Appeals Court. The first case on our list today is number 2020-1289, DEBRA Howard versus Humphrey. I'm going to probably not pronounce your middle name correctly, Mr. ORLU, so I'll say Humphrey W. ORLU, if I may. And I just want to give you a few preliminaries before we start. As you know, I'm sure you both know that you have 15 minutes to present your argument. The panel has read the entire record before today, and so we're familiar with the facts and the circumstances. So you can get right to your points. Second, Mr. ORLU, you're going to be going first, but I want you to know there is no rebuttal. After you present your argument, that's you cannot respond to anything that is said by Ms. Finnegan. Upon occasion, we have some difficulties with this remote platform. It's rare. If we do, just be patient. They usually get resolved quite quickly. So with those preliminaries aside, I'm going to introduce the panel to you. Today, the panel hearing your case is Justice William Meade, Justice Marguerite Grant, and myself, Ariane Vuono. All right, last thing I'm going to tell you, I'm sorry, is that where you see the seal on your screen, that will turn into a timer. And it'll start with 15 minutes and we'll go backwards. And so by the time you get to zero, your argument needs to be completed. All right, so Mr. ORLU, please begin.
All right, good morning. May it please the court. My name is Humphrey ORLU Jr., here to argue on my behalf. This is my first time doing this, so I'm a bit nervous. So I have a typed
Don't be nervous. You're doing just fine. Everyone's nervous when they first come to the appeals court. So you're not alone in that, okay?
Thank you. So just so I don't forget what I want to say to the panel, I have typed up what I'm going to say. So you're going to see me looking down at a piece of paper where I've typed what I'm going to say.
Okay.
My first argument is that the trial court erred when it did not compel timely discovery and then failed to dismiss plaintiff's suit and grant my application for final judgment. I made several attempts to obtain discovery from plaintiff for over 4 months, but plaintiff failed to respond during those 4 months. At trial, I moved for the court to dismiss plaintiff's suit and requested final judgment, but the judge denied both requests. I would suggest that the trial court erred because the denial of my request for dismissal and final judgment is at odds with the provisions of the Massachusetts Rules of Civil Procedure Rule 33, Section A, Paragraph 4. In the case law, Pratbo versus Hertz Corporation, the Supreme Judicial Court affirmed the ruling of the lower court when the lower court dismissed the plaintiff's suit due to plaintiff's evasive response to discovery requests from Hertz. In my case, plaintiff's refusal to provide discovery put me at a disadvantage in my preparation for trial. For example, I alleged that the plaintiff had been convicted of domestic violence towards me. I had also alleged that plaintiff was intentionally underemployed so that she could receive government benefits in the form of housing. I requested discovery related to these issues, but she did not respond in a timely manner to any request, and I therefore did not have those pieces of evidence to provide at trial.
Mr. ORLU, can I interrupt and ask a question? You're currently have requested a modification of this judgment in Georgia, right?
Yes, Your Honor. I lost my job. And
I guess you've read your former partner's brief, right?
Yes, Your Honor.
I think they make a pretty good argument about why this isn't the proper place to be litigating this. Why do you want to do this here when you're already doing it in Georgia, and you yourself asked for the judgment to be domesticated in Georgia?
Yes, Your Honor. So since the judgment was issued in Massachusetts in April of 2020, certain things have changed. I lost my job in January of January of 2021. With the loss of my job, I had to seek a modification to child support. And Deborah Howard had been living in Georgia since 2019.
Right.
So Georgia, from my research, was the place where jurisdiction lied. So that's why I filed in Georgia.
So if Ms. Howard is correct, and anything we rule on in this case won't matter because we essentially don't have jurisdiction over this case, or at the very least, it's not convenient for it to be adjudicated here. And you're in the process of working on these very issues in Georgia.
So, Your Honor, that's right. So the court in Georgia, I did, when I appeared for the first time before the judge there, I informed the judge of the appeal that's pending in Massachusetts. The judge there says any modification that will be made will be based on the judgment already issued in Massachusetts. So the relief that I'm seeking in Massachusetts, if I don't get them, the court in Georgia has said it's not going to be granting me some of those relief. So for example, one of the issues I requested in my appeal in Massachusetts has to do with child support dating back to 2018. And the court in Georgia has said it's going to be looking at the case forward here from July of 2021.
Well, when you domesticate a judgment, that gives, in this case, Georgia, the authority over all of the matters. And the judge can revisit or hear for the first time the issues in modification that you're looking for now. You can all be done in Georgia.
So the judge in Georgia has said in court that she's only going to be looking at issues going forward. So there are several rulings in the Massachusetts judgment of April 2020 that the judge in Georgia would not be looking at. So if, for example, I don't get the relief for child support for any period before July of 2021 in Massachusetts, the Georgia court is not going to be doing anything about that. So that's just one issue out of several. The issue of changes to the summer visitation and the parenting time, which was reduced, for example, also, the Georgia court has said it's going to be looking at whatever the Massachusetts court has ruled and considering whether to make the modifications or not. So it may not make those modifications. So multiple issues that I have brought before the appeals court to consider will not be considered by the Georgia court. Okay, if I may continue. My second argument is that the income attributed to the plaintiff was too low. The record shows that the plaintiff has a college degree, several certifications, and years of work of experience. She was working at a place that paid her a salary that was not commensurate with her level of education. She made no reasonable efforts to get a better paying job. She testified that she was working for St. Francis House as a rehousing specialist, a job other than that for which she had been trained. She testified that she did not need to seek employment that would pay her more because she was already employed. I suggest that she did not seek a higher paying job commensurate with her level of education and experience because she wants to maintain her qualifications for several public benefits. The apartment she was living in was government subsidized and had income restrictions. If she earns more money, she could lose a qualification for the apartment. She had access to low-cost legal aid from Harvard Legal Aid that she will be incentivized to maintain by continuing to earn less. In the case law, Cannon versus Juskalian, the appeals court affirmed the attribution of income to the custodial parent that is higher than her previous earnings. In my case, plaintiff worked a lower paying job that is other than she was trained for, and the income attributed to her should have been higher. My third argument is that my summer parenting time was reduced and moved. My summer parenting time was moved from the annual period of July 1st to around September 6th, which is a week before school resumes, to what it's currently now, which is June 1st to July 15th. My parenting time was also reduced from about 8.8 weeks to 6 weeks. While the changes to the start and end dates of my summer parenting time may be supported by the Fulton County schools in Georgia, their school calendars, the reduction in my parenting time and the start date ordered in are not in our daughter's best interest. If you see case law DiRusso versus DiRusso, 12 Massachusetts Appeals Court 892, 893 from 1981. The trial judge could have ordered a period of June 1st to July 31st for me and preserved my 8.8 weeks in all of July. The full month of July is important because it overlaps with the summer holiday of my younger daughters in Texas with me and my family. There is enough time in the Georgia summer holiday schedule for the judge to maintain my summer parenting time, but she reduced it from 8.8 weeks to 6 weeks and moved the start date to June 1st. These changes will significantly reduce the amount of summer time that our child can spend with her younger siblings and the rest of her family in Texas. My fourth argument is that the trial court did not modify child support retroactive to the date that the child support was ordered, excuse me, I'm going to repeat that. So my fourth argument is the trial court did not modify child support retroactive to the date the temporary child support order was issued on March 12th of 2019. DEBRA's complaint for modification was filed September 19th of 2018. At the time, child support was $350 per week plus $50 towards any arrears, based on the December 6, 2017 modification. On March 12 of 2019, the trial court issued a temporary order where the support amount was increased to $535 per week, plus an additional $20 per week towards any outstanding arrears. As of March 12, 2019, DEBRA was still living in Boston, and I was still incurring travel expenses between Boston and Texas for my parenting time. There were travel expenses during the summer parenting time as well. My travel expenses when I visited my daughter in Boston included plane tickets, hotel, and car rental. Those expenses were greater than the credit of $75 awarded to me in the March 12, 2019 temporary order. On October 11, 2019 at trial, the judge admitted into evidence my Boston to Texas travel itinerary. The itinerary showed a round plane ticket for one person to Boston for $396. And lodging for one day was about $303, and car rental was about $115. The total cost was $814. The itinerary did not include additional costs for parking nor an additional night during the travel. The increase made it more difficult for me to afford exercising my parenting time, yet I exercised my parenting time using my credit card. My fifth argument is that the trial court erred when it preserved the various fees levied by the Department of Revenue for the $4,000 in arrears agreed to in the December 6, 2017 judgment. The modification judgment preserved child support arrears at $4,000 based on parties' agreements. It also waived all other arrears. It waived the liens, levies, and penalties imposed by the Massachusetts Department of Revenue. It ordered a payment plan of $50 per week to be paid towards the child support arrears. I was making those child support payments as ordered by the court and gradually paying down the $4,000 in arrears. But the Massachusetts Department of Revenue imposed new levies and penalties on the $4,000.
Mr. Orlu, I just want to let you know that you have about 1.5 minutes left to finish your argument. So if there was anything that you wanted to say to us in terms of summing up, this would be the time to do it.
Okay, thank you. My final argument is that the trial court erred when it did not consider DEBRA's criminal conviction in its decision concerning awarding me joint custody of a child and exchange of home addresses by the plaintiff and I. I suggest that the plaintiff lied in her response to interrogatory number 5 concerning prior arrests. She stated that she had no criminal record and had never been charged with a crime. I suggest that she also lied during her cross-examination that she had never committed violence against me. Both parties accused each other at trial that the other party had committed violence against the other. The trial judge said she will order an out-of-state criminal offender record information for both parties. It is not clear if the judges, it is not clear from the judge's brief and rationale if the copies were obtained. If they were, then the judge would have seen the criminal conviction of DEBRA in Texas on March 5th of 2014 of domestic violence towards me. And the trial court could have found, it would have found no criminal records for me. I sent the trial court a copy of DEBRA's conviction as part of the post-trial documents requested by the judge. And I will rest my case there. Thank you.
Okay, thank you very much for your argument. All right, we'll turn now to Ms. Finnegan.
Thank you. May it please the court, Madeline Finnegan, SJC Rule 303, student attorney on behalf of appellee DEBRA Howard. I will directly address appellant's substantive claims from his brief and oral arguments and show why this court should affirm the trial court's judgment. But first, feel it's important to discuss 2 interconnected reasons why this court should dismiss this appeal: jurisdiction and mootness. By taking the trial court's 2020 order to Georgia and domesticating it there, Father has made Georgia the more convenient and jurisdictionally appropriate forum for litigation and has rendered his appeal here moot. First, this court should dismiss this appeal by declining to exercise jurisdiction under the Massachusetts Child Custody and Jurisdiction Act. Can
I just interrupt you for a second? I know that Your Honor, you were going to explain to us why it's moot after that, but your client had already moved to Georgia at the time of trial. And I'm curious as to why this issue wasn't addressed at all. It doesn't seem to have been addressed at that time.
At the time of trial, it's my understanding, based on the record, that mother had moved not permanently at that point in time, but instead had originally moved to Georgia to take care of a child who was another child that she has that was giving birth. But
the judge actually says at some point mother moved to Georgia without court permission or father's express permission. So it seems to me at the time, at least that the findings and rationale were issued, that the judge was under the judge determined that your client had moved to Georgia.
Yes, thank you, Your Honor. It's my understanding that jurisdiction is reviewed at the beginning of the case, which is when Massachusetts at the beginning of the case did have jurisdiction. So it maintains it throughout the course of the trial and throughout the appeal. But so at this stage in the trial, Massachusetts now, this court reviews jurisdiction de novo. And as mother and child have lived in Georgia since 2019, it's clear that that's now the home state of the child, is the location of evidence regarding current and future care of the child, both of which are considerations that this court.
And what if there had not been a motion to domesticate the judgment in Georgia? Would we still have jurisdiction if that was the case?
Well, neither party disputes the court properly has jurisdiction, but there are other factors in the second step of the MCCJA jurisdictional analysis that still point to Georgia as the more appropriate forum, namely that Georgia is the home state of the child. It's the location of evidence regarding current and future care, and is the location of closer connections to the family and the child. It's another important factor that father did take and domesticate the trial court judge order, or the trial court order as it stands, to Georgia and domesticate it But regardless of that domestication, it's still clear that Georgia is the more appropriate forum for this. It's the new center of gravity of the case. As such, we would ask that this court decline to exercise its jurisdiction here.
Ms. Finnegan, Mr. ORLU just told us that the judge in Georgia is unwilling to consider anything in the past in this case and is only going to be looking forward. What's your response to that?
Yes, Your Honor. While it is my understanding that Georgia will not be looking at past matters, it still remains the case that father cannot seek or obtain effective relief on the matters that Georgia won't address in Massachusetts. Something mentioned retroactive child support. While Mr. ORLU is seeking retroactive child support dated back the past couple of years that Georgia won't address, retroactive child support, the award of retroactive child support is not mandatory and is in fact discretionary. And on top of that is strongly against public policy, as the receivers of child support payments need to be able to confidently rely on their ability to spend the child support they receive. As such, without waiving my arguments on jurisdiction and mootness,
I just have one more question. Is the 2020 judgment, is that a superseding judgment, or do the 2017, 2018 judgments have any independent effect?
It's my understanding that the 2020 order supersedes the former orders, and as such, when it's taken to the state of Georgia, it remains fully enforceable there, regardless of any appellate action that this court takes.
If anything new happens, like if Mr. ORLU says he has lost his job, those are things that can be visited by the Georgia judge. Is that correct?
That is correct. Yes. Moving forward, after the conclusion of this appeal, Massachusetts cannot have any more jurisdiction over this matter, as Georgia is the home state of the child. So any future modifications to this case, including perhaps changes in child support payments because of lost jobs or other changed circumstances, must happen in Georgia, and in fact currently are, as it's my understanding, and this court could take notice of the fact that a temporary order hearing has been held in Georgia. Georgia courts are not waiting on Massachusetts courts or this court to decide.
It's a judicial equivalent of having too many cooks, would you say?
Yeah. Yes, and in fact, this too many cooks, father's best case scenario in this court, which would be an order that conflicts with the fully enforceable order in Georgia, results in something that's not in the best interest of the child, two conflicting enforceable child custody orders. And so because the only place where father can obtain effective relief, and the only way that this can stay in the best interest of the child would be to only litigate in Georgia, we ask that the court would dismiss this appeal as moot, should it not be convinced by my jurisdictional argument.
Why would there be two conflicting enforceable orders in Georgia? Why couldn't the Georgia court in other words, should this case go forward, if we reject your argument and we decide the case, and hypothetically, we reverse portions of it, again, hypothetically, why wouldn't the Georgia court respect that? Why would that necessarily conflict?
Yes, thank you. So the Georgia court did respect the trial court order and the 2020 trial court order by domesticating it in Georgia. And since then understands when it domesticated the order that an appeal was pending, but nevertheless moved forward. There was a temporary order hearing, and it's my understanding upon belief and information from our client that a temporary order was issued from the bench. And so even though any changes that are made here in Massachusetts cannot change the enforceable order as it stands in Georgia, when an order is domesticated in Georgia, it becomes Georgia's. So no action that's taken here will be able to modify anything that happens in Georgia. All modifications to the trial court order as is enforced in Georgia have to be made in Georgia itself. Should the court decline to dismiss this appeal and reach the merits of this case, we ask that it affirm the trial court's judgment. Each of appellant's claims amount to disagreements with the trial court judge's proper exercise of her discretion. Because he has not shown that the trial court judge abused her discretion with respect to any of her claims, the judgment should be affirmed. And I'll address each of appellant's claims in turn. First, father claims that the trial court judge erred in failing to ensure timely discovery by denying discovery motions and an application for dismissal, judgment of dismissal at trial. However, father's motions were either filed improperly or otherwise were not properly before the judge. However, regardless of that, and perhaps cognizant of appellant's pro se status, the judge allowed these motions to be fully heard and argued at the outset of the first day of trial, and ultimately denied those motions on the basis of timeliness, which is a proper basis for denial of discovery motions. As such, it was not an abuse of discretion to deny those discovery motions. Next up, father claims that the judge erred in failing to consider mother's alleged criminal conviction. Sorry, my screen just went weird. This issue speaks to legal custody, as the court must make specific findings in her judgment to award legal custody to a parent who has perpetrated domestic violence. At the time of trial, father produced no admissible evidence regarding the conviction. Instead, all that was properly before the judge as she made her decision were allegations of domestic violence by both parties against each other. Having heard these allegations from both sides, the judge made her decision to keep sole legal custody with mother based on the parties' inability to communicate, which she viewed as, quote, paramount to joint legal custody. The judge found that it was not in the best interest of the child to change legal custody, and because she properly considered all that was available to her at trial, the judge acted within her discretion. Next, I'd like to address the matter of arrears. Father claims that the trial court erred in preserving any and all arrears. However, father mischaracterizes the trial court's preservation of fines and arrears as an affirmation of the particularities of those fines. This seems to be an internal issue with the Department of Revenue, perhaps not an issue with translating the 2017 judgment of the trial court into a clearing of his fines and liens associated with arrears. As such, because the Commonwealth is not a party to this case, father's concern is directed more appropriately, and in fact, only appropriately, at the Department of Revenue itself. And so this portion of the judgment also should not be disturbed. Regarding income attribution, father claims that the trial court erred in its level of income attribution to mother in calculating child support payments. In fact, the court did exercise discretion in attributing mother the full amount of income at her last job, $21 per hour, which is the most money she has ever made at a job. The court was within her discretion because she fully attributed mother's past and highest recorded income to mother in calculating the child support payments as was appropriate. She also considered mother's educational degrees. In choosing not to attribute more income than she had ever made based on an unsupported job advertisement from father, which he sought to admit into evidence, the judge acted properly and well within her discretion. Regarding parenting time, father claims that the trial court judge erred in reducing his parenting time over the summer. Judges are afforded serious breadth in modifying parenting time. Father's grievance of a reduction from 8.8 to 6 weeks of summer parenting time is a disagreement with the decisions that are well within a judge's range of discretion, and as such are not subject to reversal. With regards to retroactive child support, as we've talked about a little bit earlier, father claims he's owed retroactive child support for the increase in payments he made while a temporary order was in effect. While retroactive child support is discretionary, it's also strongly against public policy, and as such, the judge's decision not to grant retroactive child support should not be disturbed. I believe that concludes my arguments. If there are any other questions, I'm happy to answer them.
A moment. Go ahead.
I just wanted to say you both did a very nice job, Mr. ORLU. This is your first appellate argument, and Ms. Finnegan, perhaps this was your first as well. So thank you all. And I know Judge Vuono has more to say, but I think good work, Attorney Yang.
Thank you.
Well, I couldn't say it better than Justice Meade has just articulated. You both did a very nice job. Your briefs are very helpful. Your arguments were also very helpful. Mr. ORLU, I don't think you'll have as many opportunities as Ms. Finnegan will in the future to appear before appellate courts. 1-2, Commonwealth versus Randy DIBIASio. A few your preliminaries. I know you both argued on this remote platform before, so I don't need to say much with respect to how this operates. If we have any technical difficulties, you know, just to be patient, and we'll resolve them as soon as we possibly can. You both know you each have 15 minutes and there's no rebuttal. So I'm just going to introduce the panel for you. My name is Ariane Vuono, joined today by Justice William Meade and Justice Marguerite Grant. Attorney Fox, please begin your argument.
Good morning, James Fox, half of Randy DiBiasio, and thank you to the members of the panel and the Commonwealth for hearing Mr. DiBiasio's appeal this morning. Briefly on the technical piece, if there's any problems on my side, please interrupt. I've already had one camera failure this morning, so wish me luck going forward. This morning, Mr. DiBiasio advances 3 claims, essentially. He argues an evidentiary claim, admission of photograph of his nieces with the eyes torn out. His probably primary claim involves the arson count, the attempted arson, and his third claim was the assault and battery dangerous weapon. I think I'll address these in whatever turn the court wants, and my initial thought is to address the attempted arson. Mr. DiBiasio's position is that the count should have been directed out, that the evidence is sufficient to show that he engaged in conduct which by itself out of context would reflect assembly of material to start a fire. However,
out of context,
if you looked at the whole thing, all the evidence, the reasonable inferences were that this was a show, not an attempt to start a fire. Under the statute,
be up to the jury to determine?
It would, but not if the question was directed out before it got to the jury. And the court may be touching on something else. The jury instruction. There was some debate about the proper jury instruction. It's not raised on appeal, but when this court rules on this claim, it might be worth discussing what the appropriate jury instruction is for this. Under the statute, assembly of material to start a fire is sufficient to be found guilty of attempted arson. However, there's a qualification in that clause, in that paragraph. There's a clause that provides that the material is assembled with intent to eventually start the fire. And DiBiasio's argument essentially is that he never was intending to start a fire. That when you look at
burners, all the burners were ablaze, right?
That's probably this is one of the few cases where essentially the Commonwealth and the defense are in agreement with what happened. There was a bit of a debate on that the Kelly, when she came into the house, testified that the burners were ablaze. The responding officers testified that they were not. You could read that testimony in harmony. However, I submit that shows more than
the jury gets the credit that they're ablaze, but there's more than that. There's gasoline upstairs. There's lighter fluid. There's a smoldering cigarette or a burnt down cigarette in the bed. It seems like more than let me put it another way. It seems reasonable, or at least rational, for a jury to have concluded that it was more than a show.
Well, the argument I'm making here is that the question should never have gotten the jury. If I could touch on the burners briefly, the burners showed that it was more of a show than an attempted arson. If you wanted to burn the house down, you would turn the burners on without igniting them. The gas would go through the house, any spark would torch the place up. The burners being full blast, you could leave them on all day, nothing's going to happen. It would be a waste of energy, but that would be the case. And to be direct, Your Honor, there's plenty of evidence here to satisfy the clause that says that if one assembles material in preparation of starting a fire, that qualifies for guilt under this offense. So I'm not going to argue that there was gasoline, there was lighter fluid, there were, but even beyond that, there were scattered weapons on the couch. There were the shattered pictures of the nieces. The house was, one officer described as just generally trashed. And the issue with the statute is when you look at the second paragraph, the standard is assemble the material. After that, the statute says with intent to, and I'm paraphrasing from my memory, with intent to eventually set the house on fire. So that is the argument right here. And was DiBiasio eventually going to set the place on fire? And, to address Justice Vuono.
What you're pinpointing, if I understand your argument correctly, is that the evidence that you've already cited to us and that Justice Meade pointed out is not sufficient to show intent. Is that what you're saying? That's just not sufficient evidence to show that there was an intent to commit arson.
Right. And what I'm saying is that look at, when I say context, the example I have is that what I was thinking about is if if you went outside, if you went to someone's house and put 2 gas cans inside the house, you're visiting someone's house, you put 2 gas cans outside, that satisfies the statute that you're attempting to burn. If what you really did was you put the gas cans there because you plan to operate your snow thrower later on, then that's a reasonable explanation. That is not intent to burn the house down. So essentially, when you look at this case right here, look at all the conduct that DIBIASIO engaged in, all the photographs that came in, that the house, the weapons strewn upon the couch.
Why is that not indicative of his intent?
Because it looks more like a show than an intent. And what exactly was the purpose of all this? The laptop being smashed if you're going to burn the house down anyway. The Patriots beer can, drinking from the Patriots beer can. The cigarette that Justice Meade referenced was put out and on the floor of the bedroom. The medicine was strewn about. This wasn't someone who came into a house with intent to ignite it on fire. And what I'd also add is, go back to the burners. Why are the burners on? The gasoline's in the bedroom, the burners in the kitchen. I mean, that there's what it looks like is the house, and to walk the facts back a little bit here, Mr. DIBIASIO was under the impression that his father stole material from him and he wanted to confront his father. And it's fair to say there's likely a fair amount of substance abuse here. And, there was an adverse relationship between the father and the son. And what I'd ask the court to consider is look at all the evidence in context. Meaning, if you look at that first clause, was material assembled that could be used to start a fire? That is clear. Did he intend to come back and did he intend to light the house on fire at any given point? That's not clear. And I'd argue to the contrary, there was no evidence that he ever intended to light the place on fire.
Well, there's almost never any direct evidence of a defendant's intent. So you have to look at the circumstances, and then the jury's entitled to draw inferences from them. And why couldn't it be a fair inference that everything he did was in retaliation from the slight he believed his father had visited upon him, and with the eventual coup de grace to be burning down the house?
I would take a look at the conduct in general, Judge, the drinking the beer can, the sitting there waiting for the police to arrive, and the continuing crash. It looks like what he did was he entered through an upstairs bedroom, kicked that in. Chaos ensued. The baseball bat in the bathroom, and is any inference available, or is this more appropriate to be directed up by the court? And then the second thing that I wanted to talk about on the attempted arson was, how should the jury be instructed on this? Should the jury be instructed? The jury was instructed that if the defendant took any step in advancement of the arson, that satisfies the charge, and that's a fair instruction. But when the court has some concern when materials assembled for an arson, the court has some concern about whether that was an unlawful presumption. So she didn't instruct on that. So this case actually presents the court with the opportunity to clear up the statute a little bit. How should the jury be instructed? Again, that issue is not being raised on appeal, but as you do address the issue being raised on appeal, it affords this court an opportunity to give some clarity to the, to future trial judges on this matter. What exactly, if materials assembled, the jury should be instructed that the assembly is with the intent to later light the place on fire. And again, not trying to sandbag the Commonwealth here. The issue is the directed verdict issue, meaning should the judge under Rule 25 have entered a required finding not guilty. But as a collateral matter, the court could comment on how this should be instructed going forward.
Could you talk a little bit about the photographs of the granddaughters?
Yes, the photographs of the granddaughters, the Exhibit 10, eyes were torn out. One girl has her Catholic school shirt on. And I'd argue to the court that that's prejudicial, that it almost implies a sense of evil rather than just misconduct. The Commonwealth argues that goes to show Mr. DIBIASIO's intent, that there was a level of malice in his actions. And what I'd argue to the court, that the question isn't whether the panel members or the Commonwealth or defense counsel see any adverse inferences here. The question is, would an average juror, be able to divide out inferences of essential evil from malice? And what I suggest,
it's actually more than that. You have to show the judge abused her discretion.
Correct. And
it's not what a juror could look at the photos and conclude.
Correct, and the lens through which that issue is addressed is the judge's discretion. And the judge would have to ask herself, you know, would a juror be able to divide those inferences? Would this be, I believe the standard is unfairly prejudicial to the defense. And when
it's whether she made an error in judgment when weighing the relevant factors such that her decision is outside the realm of reasonable alternatives.
Mhm.
I think she said a 403 analysis. We may be talking past each other, right? It is fair enough. But I'd say that, you know, abuse of discretion, but what discretion the court was trying to imply, to examine was essentially what's this cumulative. There's plenty of evidence.
Let me ask you this: what's the factual basis for your claim that jurors could view this as satanic?
I think the question is whether, well, I think the fact that their eyes are torn out as opposed to any other part of the body, it was just the eyes. It was.
And there's a witness that said that is evidence of Satanism.
No, that's the argument I'm making to the court. You've got a cross upon a girl's shirt.
Well, I'm trying to ferret out why it isn't speculative.
I think that well, I mean, speculative. Do you mean a weak argument, or do you? I mean, everything's speculation to a degree. You know, if you have a picture with the eyes torn out, you've got plenty of other conduct before the jury, which is fair to say that Mr. DIBIASIO was in a heightened state of agitation, and the defense particularly tried to get these two pictures out. I think particularly Exhibit 10, and you know, the certain symbols do. It may be on speculation, Your Honor, but it would be, you know, if someone drew a swastika someplace. It's speculation that somebody would take an adverse inference to that, but also it's a fair inference.
But he didn't obliterate the part of the niece's shirt that had the cross on it.
No, but he obliterated the eyes, which was the he obliterated the eyes. You're correct, Your Honor. So
does it matter as these photos relate to the intent for the arson? Does it matter whether the Commonwealth's theory was that he broke into the house intending to commit arson and he did all this vandalism first, or he broke into the house, did the vandalism, and thought about setting the fire to cover up the vandalism? Does that matter? Or do you know from the record which it was?
I didn't see that theory. The theory, and of course, the Commonwealth's available to speak for herself in a moment, but the trial ADA, her theory was that the material was assembled in preparation for arson. That satisfied the statute. And that's what she tried to press the trial judge on with the instructions at the beginning of, I believe,
were the photos part of the material that was assembled? Or is it the flammable stuff that's assembled?
No, the photos and the flammable are two different things. Essentially, the statute provides, I believe, there were two cases, and Justice Meade is one of the authors of them, Cotu and Alley. In fact, it's either Justice Meade or Justice Holmes for all the law here, and I think Justice Meade, since he's with us, he controls. But the standard is to you know, was material assembled in advance of a fire, and what Commonwealth. And again, I can't speak for the Commonwealth, but my read of the record is that ADA McDougal relied upon the assembly of the flammable materials, primarily in the bedroom, to show the intent to light the place on fire. The picture is a different issue, and that more goes to whether the jury was inflamed. Pardon the pun right there. Whether the jury was aroused when they viewed the facts. It's a final matter, you know, as my wife likes to say, when I win a point, I still keep on going. And I know the Commonwealth conceded the assault issue. So, you know, on different grounds, would the court like me to address that? I know that the court is the ultimate arbiter of whether the claim survives.
I think we're okay. I guess I can't resist saying you have a wise wife, but I don't mean that.
No, she says, like, even when I'm right, when she concedes the point, but on the wrong point, on the wrong basis, I still want to, you know, keep on going. So I'm trying to follow her counsel right here to stop talking on that one.
Congratulations on being right with your wife.
Fair enough.
Let me check with the panel to see if they have any additional questions for you. I see none. No, thank you very much, Attorney Fox.
Thank the court for response.
Okay, we'll turn now to Attorney Jansen. Good morning.
Morning, Catherine Jansen on behalf of the Commonwealth. The Commonwealth would ask the court to affirm the defendant's convictions with the exception of count 7, which is assault and battery on a person at age 60 or over. I'm happy to address that claim if the court wishes. Otherwise, I'll address the 2 other claims. Just to briefly
I have a question about that claim.
Yes.
We see these things sometimes, and I know appellate courts get frustrated that there aren't more specific verdict slips or more specific acts instructions. Do you have any sense of why there wasn't a request for a specific act instruction in this situation?
I don't, Your Honor. From the record, I don't. And also, I think from this is obviously not on record, but from speaking with the trial prosecutor, I honestly think there were a lot of counts, and it just, quite frankly, went over everybody's head involved in this, and it was an unfortunate mistake, which, you know, obviously we try to learn from our mistakes and correct it in the future. But based on the record, in fact, the verdict slips weren't specific, and it wasn't specifically addressed which act or which conduct supported count 5 or count 7. There's a significant risk under Kelly that the jury could have convicted on the same act behavior. To briefly address the first issue of the cutting out of the eyes of the pictures, that evidence, but the judge did not abuse her discretion. That evidence was highly relevant to the defendant's intent, not only on the issue of whether he maliciously intended to start a fire, but also the assault of crimes of specific intent to murder his father, which was a charge that the Commonwealth had to prove. And so and there was no implication at trial that there was possible satanic messaging. The prosecutor directed the jury the appropriate use for this evidence, which was look at the defendant's intent, specifically in light of his defense, which when the judge ruled that this would ultimately be admissible when the prosecutor went to sidebar before admitting the pictures, that, you know, the defense at trial was there's no intent to harm. This is motivated by drug addiction. So that tended to combat that, and that there was just no risk that the jury would improperly use it, that they were going to use this for the correct purpose. Just to also briefly address the sufficiency of the evidence for the attempted arson. You know, my brother's arguments focus basically on basically what the jury could look at. They could look at it in one way or they could look at it another way, but when we're reviewing the sufficiency of the evidence, it has to be in the light most favorable to the Commonwealth. And if there are conflicting inferences, they go in favor of the Commonwealth. Here, there was more than sufficient evidence that he committed a preparatory act with the intent to burn. Ultimately, the fact that the stove burners were on, he had moved gasoline containers upstairs from the basement, along with evidence of his anger to his father, preparation for an attack by placing weapons around the house. That was more than sufficient in this context to prove his intent. As Justice Meade noted, intent is very rarely proven by direct evidence, and based on the facts and circumstances of this crime, this was sufficient. If the court has no further questions, I'm happy to rest on my brief.
Let me check with the panel. I see no further questions from either a panel member. I have no additional questions. 2021-0151, Commonwealth versus Vincent Lucas. Quickly, as you both know, I'm sure you have 15 minutes to present your argument. There is no rebuttal. On this remote platform, upon occasion, we have some technical difficulties, like we just lost Attorney O'Meara just now as I was saying that, the further problem. So I'm joined today by Justice William Meade and by Justice Marguerite Grant, and my name is Ariane Vuono. Let's begin the argument.
In this case, the appellant argues that there was not enough reliable evidence to convict, and therefore his motion for required findings should have been allowed. I think in this case, there was a general lack of reliable evidence. The only specific evidence of guilt was the alleged victim's own testimony.
Is that enough?
I think under certain circumstances, it could be enough. I know if you read Santos, it's a different sort of case, but yeah, if you read Santos, that is enough. I argued this prior to Santos. But when
looking at the evidence in the light most favorable to the Commonwealth, which would mean the jury is entitled to credit the victim's testimony.
Well, I know that, you know, and I know, Your Honor, that you know, credibility is in the hands of the jury. But in this case, you know, there wasn't really anything else aside to testimony. And quite frankly, because of the facts of the case, you know, there's all kinds of scenarios that could have happened here. I mean, there was no real identification at the scene of the incident. There was no witnesses to the assault. There was no medical or forensic evidence of even an assault in this case. No rape kit, no cuts or bruises. You know, there was potential evidence at the crime scene that should have been collected that wasn't. There was no swabs of any kind taken from any of the clothing that was.
You said, Mr. Amir, you said there was no identification, but the victim did pick the defendant's picture out of a photo array.
Yes, that's correct, but it doesn't mean that there was that a rape occurred. And I understand. I mean, I know that he was acquitted of the more serious rape charges, but yeah, I mean, I understand that. That's, you know, that's well, if you're talking about photo IDs, I think that the photo ID was flawed.
That's not an issue you've raised on appeal, though.
Sorry.
That's
Yeah,
not an
I know.
issue you
I
have raised on
probably-
appeal.
Yeah, that's correct. I probably should have, but you know, that is, I think that is a fact. And I understand I didn't present it on appeal.
Given the fact that the jury acquitted your client of the most serious charges, the 2 counts of rape and the strangulation or suffocation, can't we consider that maybe they already took the victim's credibility into consideration?
Yeah, I mean, I think that's a really good point, Your Honor. I thought about that. You know, I thought it might have gone the other way, but I would agree that, you know, they didn't convict him of the 2 serious charges, as you said, of rape. He was convicted of the 2 assault charges, and again, you know, I don't know. You know, the evidence for that I think is really wanting. And I know again that, you know, the credibility is for the jury to decide, but you know, this was a very interesting case in that, you know, the victim had really other motives for identifying the defendant. I mean, she was a known drug abuser, and I think probably that should be factored in also, that, you know, that you know, she wasn't the most reliable witness. And I think you're right. I mean, I think that she wasn't a reliable witness, and I think the jury saw that. But they, you know, they acquitted him of the rape charges, but he was convicted of the 2 assault charges.
Do you want to address the motion for new trial?
You know, for that issue, Your Honor, I'd like to rest on my brief. I have read Commonwealth's brief, so I think it's probably best that I rest on my brief.
Okay.
Unless there's any questions.
No, I don't have any questions, and I'll check with the panel. I don't see that they have any either. All right, so have you concluded your argument, or is there anything else you want to tell us before we move on to hear what the Commonwealth?
I've finished, Your Honor. Thank you.
Great. Okay, thank you very much. Attorney Rawl?
Thank you, Your Honor. May it please the court, Ryan Raw for the Commonwealth representing the County of Middlesex. Your Honor should affirm this conviction first because there was sufficient evidence to convict on assault with intent to rape and assault and battery convictions. Simply put, the relatively new Santos case controls, and there's no caveats in the language of Santos. It quite simply says the victim's testimony in a sexual assault case is sufficient evidence that, in fact, that something occurred. I mean, it shouldn't need to be said, but it was said in the Santos case clearly, and that controls. And the facts in this case, in the light most favorable to the Commonwealth, was that the defendant abruptly attacked the victim after getting her alone in a darker, more secluded area of the park, used threats when she attempted to resist, as well as, used blows when she attempted to resist and pulled her down to the ground, started removing clothing, and also made statements at the time that suggested he was going to sexually assault her. And putting all that together, it's clear that there was sufficient evidence. And then moving to the second argument was the motion for new trial. I would just simply say that the Buckley case controls. It's over 10 years now that we use a elements-based approach, not a conduct-based approach. And I believe that the Pinero case that I cited in my brief makes it clear that the analysis is that assault with intent to rape is not lesser included with assault and battery, or sorry, vice versa. And as a result, the jury instruction wasn't even applicable. So based on all that, I would just rest on my brief if there's not any questions.
I'll check with the panel. I see we have no further questions. Thank you both very much.
Thank you, Your
Thank you,
Honor.
Attorney Amira, for your patience in joining us today. Just the preliminaries, because I know that you both have argued on a Zoom platform before, and so you know the rules, and you know the rules also of oral argument. I'm just going to reassure you, as I do before every case, that if we have any technical difficulties, they're usually resolved quite quickly. Any problems will be resolved, and no one will lose any time with respect to their argument. So with that said, Attorney Dolberg, please go ahead.
Thank
And I
you.
want to remind you the case is partially impounded as we go forward.
Thank you, Your Honor. My name is Nancy Dahlberg. I represent IMER SOTO, and this is an appeal from Mr. Soto's convictions for rape and kidnapping. His sentence has been stayed pending this appeal. The issue at trial was consent, and our appellate arguments all go to that issue. Because there are a number of them, I'd like to focus on two of those today. And the first one of those is the trial court's preclusion of a question on cross-examination about the only documentation of the alleged kidnapping. The alleged kidnapping was a highly contested issue at trial. And there was a videotape of the event that was lost, but it had been viewed by a witness, Paul Daniels, who was called by the Commonwealth. And Mr. Daniels had reported to the police what he saw on that video. He didn't recall initially when questioned what was on the video, but his recollection was refreshed. And the defendant, and what he saw as reported by the police was crucial to the defendant's case. It basically said that he didn't see what the alleged victim said happened to her, which was that she was pulled into the car.
Let me interrupt. Attorney Dahlberg.
Yes.
I don't want to talk over Justice Meade, but
You said I'm sorry. He said his memory was refreshed, but I think he said only to some extent.
Yes, he said to some extent, and then he said he didn't recall much more than a particular memory. But he was never, the judge did not allow the question to be asked of him on cross-examination. So fair to say you did not see anyone pulled into the car. Now, what this witness recalled seeing was a non-adversarial interaction, conversation outside of the black
same thing though? If the police report says it didn't appear to be adversarial, did not seem to be adversarial, and it appeared to be a normal conversation. Is that the same thing as he didn't see anyone pull her into the car?
If I may, Your Honor, he actually also he said he saw two women enter the back seat, and the interaction was non-adversarial and non-adversarial. Now, we don't know what he would say. Maybe he would say, I don't recall seeing no one pulled into the car, but that's the clear suggestion from what he saw. He reported this to the police very soon after the event. Unfortunately, the video isn't there, but this went directly to the defense case, and the defendant had a right to ask it on cross-examination. It's good faith basis. There is not clear that the witness's memory was depleted. It's not clear what his answer would have been, but there was a good faith basis to ask it. And as we say, it goes directly to the question, something that the jury struggled with, by the way, because the defendant testified absolutely contrary to what the alleged victim said. The friend who was present did testify at the trial that the alleged victim was pulled into the car, but she had testified prior that she was emphatically not physically pulled into the car. She talked to whomever was in there and was not pulled into the car. Best friend told the police on the night of the event that the alleged victim looked at her and said, grabbed her arm and said, "Let me go." The jury, so it was, quite unclear to the jury, apparently what happened, because they asked to see the prior testimony of the friend. And then they said they were at an impasse on this charge at the same time that they had indicated that they had reached a verdict on the other charge. And so the question about cross-examination, as we know, is, does it go directly to the core of the defense, the issue? Here it did. Here, the question really needed to be asked. And the defendant was precluded from doing that. So we argue that that's constitutional error, not harmless beyond reasonable doubt, requiring a new trial. If there are no more questions on that issue, let me move on to the instruction on intoxication, on incapacity consent due to intoxication. And that created a substantial risk of a miscarriage of justice for 3 reasons. First of all, there was no evidentiary basis for giving the instruction. The alleged victim was very clear that she remembered the events as she reported them. It's very specific. She said she had been drinking over a lengthy period of time with her friends, and as she used the words, had a buzz on.
Can I ask, this victim consumes an enormous amount of alcohol over several hours, and the police had trouble getting information out of her and her friends, and she was described by several people as being very intoxicated. So is it your claim that one has to be unconscious for Blake to kick in?
No, Your Honor, that's not what Blake says. Blake says the question is whether, as a result of consumption of alcohol, she was unable to give or refuse consent. So intoxication isn't the issue. It's inability to consent or refuse. But I would like to take a little bit of exception to the description. The police did not have any trouble talking to her. Her own description of her being was that she was not intoxicated to such a point. She felt a little looser, had a buzz, but she was not slurring her words, throwing up. She remembers everything. Her testimony was absolutely very specific. The Commonwealth's attribution to her being frozen was not due to alcohol. She described that as a means of protecting herself. In terms of her,
if the judge had given the part of the instruction, the model instruction that you want, you're saying the part about,
for example,
mental retardation and helplessness, isn't there a risk that a juror might think, well, the fact that she was frozen shows that she's helpless, and that's enough for consent, non-consent?
So the way that, as Your Honor knows, the way the instruction, the model instruction is set up is that there's an indication of the basis on which the instruction is being given. The exemplifying language was intended, as Blake, specifically said, and maybe in part, Blake, as we know, was the opinion did not represent the full court. There was a strongly worded dissent because it was fear that this instruction would be too low, for its purposes. And so they have, so the court very specifically said that the language that was left out is intended to communicate to the jury that intoxication must be extreme before it can render a complainant incapable of consenting to intercourse. That the exemplifying language would not provide a theory. I don't believe, Your Honor, for finding that, but she was very specific when she used the word frozen to describe that she said she was shutting herself down to protect herself mentally. had nothing to do with intoxication, no suggestion of that. And I would just add, and I know the court is aware, that the trial prosecutor specifically rejected the idea of this instruction. And presumably that's because she understood that it wasn't warranted in this case.
Well, it could have been a tactical thing that, as far as the credibility of the victim, but my question is, so both sides didn't want this at the charge conference, but then the jury asks a question.
Right.
What's the judge supposed to do in response to that question?
I think under these circumstances, she would have to have indicated that that is not a theory on which this case is being tried. And that actually goes to the third problem here, which is that the defendant was denuded of this defense, which would have been a very strong defense for him if he had known that he should argue it. But it was specifically indicated to him that he shouldn't argue it because it wasn't a theory in the case. And
He's
so
seen counsel at the time, they all agreed at the charge conference that the judge should give this instruction. So what's along the lines of what Justice Grant asked, what's the trial judge supposed to do at this point?
this wasn't a theory on, well, first of all, Your Honor, I argue that there wasn't a basis for giving it, so she shouldn't have.
Yeah, I remember that. But no one argued it.
No one argued it, and so the jury clearly thought of this on its own, because there was talk about these young people drinking at the Super Bowl, right?
Because there was a lot, substantial evidence in terms of their intoxicated state.
No question there was evidence about drinking. Now, whether the only evidence about intoxication really came from the friends, and the only description of what highly intoxicated was, which came from Lindsay, was not something that would equal an inability to consent or refuse to consent. She said they weren't causing a scene, they were walking fine. What anyone meant about intoxication is unclear, but this instruction is clear that intoxication isn't the question. I would just let me return for a second to the defendant's inability to make this argument to the jury, which clearly the jury was interested in intoxication, but they weren't instructed properly on it. They shouldn't have been given the instruction, but the defendant had no opportunity to argue against it. And there was a lot of information available to him to argue. She indicated twice that she said no, that she refused to consent in the vehicle. She said that she remembered everything and that she essentially wasn't drunk. And this is completely different from the cases cited by the Commonwealth and really all the cases after Bleach, which talk about people being very intoxicated. And I realize this, although the instruction says unconscious or in a stupor, and that isn't the law, even the current instruction says that. And the implication, as well as Bleach says, this is a very extreme situation that somebody, and the current instruction actually uses the word unable, and it bolds the word unable.
So just to be clear, to summarize, your position is that when the jury asks these two very specific questions about the state of law in Massachusetts, the judge should have said, you can't consider that, and moved on, and not have answered the question directly?
I think that the judge could have said yes, but the judge could have said yes, but it's to instruct as a theory. This is an element of the offense. This was the entire instruction on the element of lack of consent due to inability to consent because of intoxication. This is all the jury heard about it. And it's pretty clear, it's very likely, that this is what they based their verdict on because of the timing. They came back with the instructions the end of one day. They're adjourned essentially. Although they're given the oral
that's
instruction.
always hard. That's always hard to say. There could have been one juror who had a question about this.
Yes, and of course it doesn't matter because if that was the possibility, then we need a new trial because there were two theories. But the timing suggested very strongly because they deliberate the next morning. By noon, they're back saying, we reached a decision on rape, but we're at an impasse on kidnapping. So yes, I would like to primarily rest on my brief as on the most of the rest of our issues, well, all the rest of our issues, which all go directly to credibility and consent. I would just like to point out briefly that the prosecutor's closing, linking the alleged victim's examination with her credibility, her consent to go through with that is clearly error, was objected to. It was overruled. There were no curative instructions. So I would just say, along with many other issues going directly to credibility in this issue, it requires a new trial. So I thank you very much.
I just have one question
yes.
on the first issue in your brief, and I realize that you didn't write it. Has this court or the SJC ever put a limit on how many investigating police officers can testify?
Not to my knowledge, Your Honor.
Thank you.
Okay, thank you very much. We'll turn now to Attorney O'Sullivan.
Good morning, and may it please the court, Shane O'Sullivan for the Commonwealth. With the court's permission, I'd like to first address the issue of the consent instruction. Under Blake, this instruction should be given regarding intoxication. That's the language the court uses there, should be given in any case where intoxication evidence would support it. I think under the facts of this case, it was proper to give this instruction and all parties agreed to it.
What if the evidence was that the victim had one beer and she said she was fine and she seemed to be fine, and there happened to be a juror or more than one juror who thought, well, if she's drinking, she can't consent? Should the judge give the ablation instruction in those circumstances?
Well, I think at that point that the judge has to make a determination. Does the evidence support it? I think, under if that was the only evidence of intoxication, then that would probably be a tougher call for the judge to make, and maybe we would probably be justified in not giving it. However, under the facts of this case, where the evidence clearly did support it, it was proper, appropriate, and I think almost required to have given it. The jury is instructed, consistent with a normal consent instruction, the base consent instruction, which was given in this case, that they may consider all of the circumstances in the entire sequence of events. So I don't think there was any way that you could really get around the intoxication with the consent issue in this case. I think the jury was prudent and intelligent in asking this question. They recognized that this was a part of what they had to consider in considering all of the circumstances. And once they asked the question, it was entirely appropriate for the instruction to be given.
What do you say about the fact, Attorney O'Sullivan, that what in terms of how this came about? In other words, both parties say to the judge, we don't want an instruction under Commonwealth versus Blake at this point in time. The jury, as you say, perhaps more than prudently raises the question: why don't what do we do about this? At that point in time, neither the Commonwealth or defense counsel can really directly address the issue. Doesn't that put this in a little bit of a different situation?
Well, I think if there had been an objection, then certainly we would have to evaluate this differently. But because there was no objection, right, part of the substantial risk evaluation is, was there a potential tactical reason behind it? And I think if you look to the defendant's closing argument, especially in the defendant's theory of the case, the instruction that mere consumption of alcohol alone does not invalidate consent was arguably very important for this defendant. The defendant's theory of the case was that this victim was out drinking, was out partying, had a one-night stand, and then was embarrassed about the fallout, that her parents were calling her, was trying to explain it to her boyfriend, and invented this story. In closing, defendant argues victim was drinking, partying, and had a one-night stand. That's on page 119 of the closing transcript. On page 122, which is the The last thing defense counsel leaves the jury with in the closing argument is he states that the victim had been drinking, quote unquote, all day. Then defense counsel played a video of the parties drinking and partying together and stated it was that victim who met the defendant that night, not the version who had testified. So it was very important to the defendant, under his theory of the case, I think, that the jury be aware that mere consumption of alcohol alone does not invalidate consent, because if they had had a misinterpretation of that, potentially, it would be bad for the defendant if they had misinterpreted that and thought intoxication invalidates the consent. We can't find consent if the victim was intoxicated. So that portion of the instruction, I think, was very important for this defendant. And given that he agreed to it, I think that's evidence of that, and why this court should not find a substantial risk of a miscarriage of justice. The remainder of the instruction was proper. It provided that the person needed to be, that the victim needed to be so impaired as being capable of consenting. In regards to the reference to sleep, unconsciousness, mental retardation, or helplessness, I don't believe that that was necessary. Blatch, first off, refers to those states in the disjunctive, using the word or to separate those states from intoxication. So I think that's an indication. And the defendant's reliance on the Urban case, first, I think, is an opposite, because Urban dealt with a pre-Blatch instruction. So that's I think, a critical difference between Urban in this case. And furthermore, Urban held that listing, and I think the opposite of what the defendant's saying, Urban held that listing intoxication alongside those other conditions was improper, because the jury could interpret any amount of intoxication as invalidating consent in those instances. I guess it's essentially that because sleep and unconsciousness, there's no level of sleep and unconsciousness that can equal consent, right? You can't consent when you're asleep. You can't consent when you're unconscious. If you then lump in intoxication with those, the jury might get the impression that they treat it the same as sleep and unconsciousness, which we know that they don't. So I don't find that the Urban case to be persuasive there. The instruction was perfect. The instruction was...
Mr. O'Sullivan, can you get to the witness, Mr. Daniels?
Sure. The extent of cross-examination is within the trial judge's discretion. I would suggest that Daniels' testimony here indicated that he had no independent memory of the video. Defense points to the statement he made, "I can't remember much more than that." And I think that statement really needs to be put in the context. He is asked, what does he recall? He then repeats the facts that he recalls, and he ends that statement with, "I can't remember much more than that." I would suggest that it's more a kind of colloquialism he was using to sum up what his memory was. And I would suggest that the defendant's kind of hyper-technically parsing that one statement. But even if that left the door open for him to have some memory beyond what he recited, the trial judge followed up immediately after that with a question, a pointed question. "Is that what you remember seeing at this point after reading that report?" And the witness replied, "Yes." So any door that was left open by "I can't remember much more than that" was immediately shut by the trial judge by the pointed question thereafter.
You said that the defendant didn't have a factual basis for the question, but McDonough's report, which was used to refresh the witness's recollection, doesn't indicate anyone being pulled into the car. Why isn't that a factual basis for the question?
Well, McDonough's report is hearsay. Daniels is, unfortunately, the video was lost, and unfortunately, Daniels is the only witness that could testify to what was seen on that video. There's no other witness that could come forward and put in admissible evidence of what was on the video.
So let me ask it differently. Because you said there was no factual basis. Now are you saying there was an inadequate factual basis?
Well, what I'm saying is there was no witness or piece of evidence that the defense could anticipate that would come forward that would support that proposition once Daniels does not have a memory of it.
Well, what counsel was probably going to get was either an "I don't know" or "I don't remember" or "No, I don't recall seeing anyone pulled into a car," which seems to be pretty important to the kidnapping charge.
Well, I think what counsel was going to get was, and I don't remember, and
We don't know
I-
that. though.
well, I think we do know that because the witness testified that his memory to what his memory was, and it didn't include that detail. So the only way that would have been before the jury would be by suggestion within the question. I'd point the court to the Knowles case, which is cited in the Commonwealth's brief, which I think is very similar. In that case, a witness testified they didn't recall a certain conversation. And then there was a series of questions about specific prior statements, within that interview that the witness didn't recall. The court said that was improper. I think it was the same thing here. Witness is saying he only remembers so much. To allow specific pointed questions about details within that the witness doesn't recall, I would suggest is just trying to backdoor that information through innuendo within the question.
If we assume that the judge's limitation was an error, why isn't this prejudicial?
Well, I would look to the report, which is quoted in the defendant's brief. I believe it's in the defendant's appendix as well. And I would push back on the defense characterization of the weight of that evidence and the importance of it. For one, the report says that the video shows two females enter a motor vehicle, right? It also says that they were not able to tell on the plate number, an identity of this vehicle, okay? Both the witness Nicholas, the victim, and the defendant himself all testified that Miss Nicholas never entered the car. So the fact that this shows a motor vehicle with two females entering is inconsistent with even the defendant's own version of this. The defendant also testified that the initial encounter happened on the street and they entered the car thereafter. This encounter appears to be two females having interaction with someone in the vehicle and then entering. So even if this was before the jury, the defendant contends that it would have bolstered his account of events, but there are also, I think, considerable portions of this that contradict the defendant's version of events, and contradict the version of events of the other witnesses as well. So I would submit that this was not as critical of a piece of evidence as the defendant would characterize it. And so that would be, I think, the main crux of the prejudice prong that I would like the court to focus on. In regards to the prosecutor's closing, which I know was raised, I would address that briefly with the court's permission. The defendant in this case squarely placed into issue the issue of the victim's credibility. That the victim made an emotional disclosure to a trusted family member in the immediate aftermath of the crime was, I think, a proper argument as a reason to credit her testimony. Even under the first complaint doctrine, the freshness of a complaint is still an important factor. This was a fresh complaint that was made. The only objected to portion of the closing argument was the victim being, the statement that the victim was being poked and prodded. This brief reference was tempered by instruction not to decide the case on sympathy and that closings are not evidence, which I would submit sufficiently protected the defendant from any prejudice, and I think the jury would have been able to discount that hyperbole in this particular instance. I would also just like to briefly address the medical records because there were a portion of those that I think the Commonwealth would concede were probably better left redacted, but I would just remind the court that there was no objection to this. The entries were couched within 20 pages of reports, would have largely been understood to have been part of allegations, not medical findings, and were also tempered with the sane examiner's testimony, who stated that there was no independent examination done at the hospital, or independent investigation, done at the hospital. The victim was treated solely based on her representations, and most importantly, that what she observed and recorded was within normal limits for consensual intercourse, which also helped the defendant's case as well. So for all those reasons.
What about what about the diagnosis of sexual assault and assault in the records?
And those are again the portions that we would concede were probably better redacted. It was, I think, missed by all sides. They clearly tried to do redactions because they did a sufficient or significant number of redactions on other documents. But again, because the same examiner testified that there was no independent investigation done, that the victim was treated solely based on her own representations, and then most importantly that what she observed was in normal limits for consensual intercourse. The jury, I don't think, would have been misled by that to have understood there to have been any diagnosis of a sexual assault. I think the same examiner did a very good job of thoroughly describing, what that entailed, and again would have tempered those limited references in a 20-page report that probably should have been redacted. I'm seeing my time's running short. If there are no further questions, the Commonwealth would rest on the brief.
Okay, just one moment. I'll check with the panel to see if they have any follow-up questions on any points. I see none, so I'll plan that that Attorney Cavani and Attorney Van Ostrand are going to split their time 12 minutes and 3 minutes. Is that correct?
That's correct.
All right. With that said, we can now start the case. I'll start our arguments. I'll call the case first. 2021-0437. This is Gary McCool and others versus BEECHWOOD INN. A few quick preliminaries. If you're not familiar with the remote platform, we've had success throughout the day today, so I don't want to jinx us, but if we do have any technical difficulties, please be patient. Any problems generally get resolved quite quickly, and no one will lose any time as a result of any problem that we may incur. Let's hope we don't incur any. I'm going to introduce the panel to you. I'm joined today by Justice William Meade and Justice Marguerite Grant, and my name is Ariane Vuono. We've already covered what the time frame is. I remind you, Attorney Boscovich, that there is no rebuttal in the appeals court.
I saw that, Your Honor.
Okay, with those preliminaries, you may please begin your argument.
Thank you very much, Your Honor. My name is Tony Boscovich. I am appearing pro hoc vice on behalf of the appellants, who I will call the McCools, and the appellees I will simply refer to as the defendants, to make it a little easier. Your Honor, this appeal is about 3 words: dismissed with prejudice. The Superior Court issued its order, and the appellants, the McCools, appeal from that order. It is important to note that the order relies on one issue and one issue alone, and that is standing. The court does not address any other issue in its ruling. Now, the standard of review, we all know it's de novo. And what de novo means is as if the order did not exist. The court reviews the pleadings, the record below, and that's it. So much of what the appellees have argued, the defendants have argued, is simply irrelevant. Arguments that were made, motions that were made, all of that is irrelevant for your purpose in a de novo situation. In this case, however, there is a nuance. The only thing that the McCools could appeal from was the Superior Court's order. And the Superior Court's order only referred to one thing, and that was standing. Now, it is true that this court can review all of the allegations in the pleading and make a decision based for other reasons. That's
Let me ask you a question, if I may, Attorney Boscovich, and that is this. Of course, our review is de novo. We understand that. But the judge in his memorandum and order points to the following fact, and that is that the two named plaintiffs in this case, the estates of the McCools, of both McCools, are not, and I'm quoting from the decision, are not alleged to be owners of the stock certificates, which forms the basis of this lawsuit. Can you point me to any place in your complaint where that is? Okay.
Yes. Paragraphs 2 and 4 allege that Gary McCool and Matthew McCool are personal representatives. Paragraph 5 indicates that George E. McCool passed away on April the 14th of 2016. Paragraph 6 says that Jeanette McCool passed away on October the 30th of 2018. Paragraph 44 says that at the time of death, George McCool had an equity interest in his name. And paragraph 45 says that upon Mr. McCool's death, Jeanette McCool became a shareholder by operation of law. If you apply a Rule 8 standard, and remembering that judges and justices are not supposed to park their common sense at the door, nor are they to forget their judicial experience, this is enough to say who owns it. Mr. McCool died. It passes to Jeanette McCool. There is a probate action that is pending right now. Now, of course, you could amend and say, and they are now owned by the estate of Jeanette McCool. But thinking back, giving every reasonable inference and accepting everything is true, based on the allegations of the complaint, who else could own the shares but one of the plaintiffs? Because
Well,
there is.
could Mrs. McCool have had a will leaving the shares to some charity?
But there's no allegation in the complaint that says that that estate has been probated and that those shares have been devised or have been disposed of. However, yeah, you know, if a court isn't willing to accept that the share wants, what I would call magic words that says exactly and explicitly, more like a Rule 9 specificity pleading, we can amend easily. And quite frankly, this gets into the with prejudice argument, which is that, you know, you should only dismiss with prejudice unless no amendment could cure the defect. And additionally, with prejudice runs afoul of Rule 17, which allows substitution of a party. So let's say the owner is a trust, which doesn't happen to be true. It's all still in probate. You could Rule 17 allows you to substitute in that entity who is now the owner of the shares. But what the Superior Court did was, by dismissing with prejudice, foreclosed it. It's over. You didn't do it. And that violates all the rules with respect to leave to amend.
If we let you amend, are you going to be able to produce the stock certificates?
Your Honor, my understanding, the stock certificates are available, and there are allegations with respect to those stock certificates. Those stock certificates were withheld by the defendants for decades. When they were turned over, they are there. I can tell you, yes, we can turn over the stock certificates. We have what the defendants claim to be the stock certificates.
And are you saying that, as the judge pointed out in a footnote in his memorandum of decision, that at the time apparently of argument in this case, counsel asserted that the stock certificates are held in a trust by the estate of George McCool for the benefit of the estate of Jeanette McCool? Is that what you would be intending to if you could amend your complaint a fourth time, that would be what you'd be alleging?
No, and Your Honor, I'd like to address it. Absolutely not. The Superior Court got that when Attorney McCool attempted to explain what a personal representative does. And so the personal representative essentially holds the assets subject to distribution by the probate court. The Superior Court apparently latched on to the word trust. It was nowhere stated, nor would we allege. There is no trust. They are in the estates. They are in the estate of right now of George E. McCool, and Jeanette passed, but the probate court has not yet acted. Additionally, Your Honor, I want to address the fact when you talk about the 4 opportunities. Although that sounds like an interesting fact, it is inaccurate. If you look at the document, what happened was July 26th, initial complaint of 2018, August 13th, a first amended complaint as a matter of right. Nobody had appeared or anything. A motion was filed on December 17th of 2018 to file a second amended complaint, which was allowed by the court. And the only evidence that this court has or anybody has is that the Superior Court said that the defendants raised some legitimate concerns and that they should file either a Rule 12 motion or a Rule 56 motion to address those concerns. We don't know what those concerns were. So we just know that the court said, please file a Rule 12 motion. What did the defendants do? They answered. They put the case at issue. Now you can forget those first two. Now the clock starts running again at the second amended complaint because they answered. Now we come into June of 2020, the third amended complaint is filed. And for the first time, the Superior Court is presented with an issue for it to decide with respect to the standing of the defendants. So it is unfair and inappropriate to claim that this is the fourth bite at the apple. It's not. It really is the first bite at the apple because they had answered the second amended complaint.
Judge Wren says that you were on notice since 2018 of the deficiencies in the complaint. So how many times did you amend after 2018?
After 2018? After 2018, looking at this, twice. Once was the second amended complaint, which was answered, and then this verified third amended complaint.
So, but in neither of those amendments, did you directly allege what you've told me in response to my question about the existence of the stock certificates in the possession of the estate?
With respect, Your Honor, number one, that is not in the record and therefore shouldn't be considered by this court. Now, if you're going to be talking about the with prejudice is, were you warned? The answer is no, not necessarily, because they answered the second amended complaint. Now, if you can imagine sitting from the plaintiff's perspective, I file my pleading that the court has allowed. The court has said, if you might want to bring a Rule 12 motion. They chose not to do that. They chose to answer. That answer tells the world, all right, that you are satisfied with the form of the pleadings. You may not be satisfied, for example, standing is always at issue, but you are satisfied with the form of the pleadings. Then, when the third amended complaint gets filed, they say, "Oh, we have a standing issue based upon these paragraphs." At that point, all the plaintiffs can do and offered to do, and I will offer to do, is we will say who owns the shares. The shares are owned by the estates, period. There are no trusts that are involved. They have not been sold. They have not been gifted. They are owned by the trusts. And if we amend to say that, it is cured. It is absolutely cured.
But why didn't you?
Why didn't we in the first one? Well, Your Honor, I will say that I believe that Attorney MACKOUL thought that he had adequately alleged it, based upon, if for no other reason, that the defendants had answered the second amended complaint.
Yeah, but filing an answer does not preclude a future Rule 12 motion.
Absolutely does not. But it doesn't. But if you answer and then you come in on a third amended complaint and say, "Hey, you've had 4 chances and you've done it," well, no, that's wrong. If they had had a problem with a standing allegation with the second amended complaint, as Judge Wren suggested, they needed to file their Rule 12 motion. Then they could have said, "Well, you've now had 3 chances. This is your 3rd chance, not your 4th.
But they can raise subject matter jurisdiction at any time, though, right?
That is correct, Your Honor. But the policy of the law is, with respect to standing, A dismissal with respect to standing is not a decision on the merits. And there is a strong public policy in the Commonwealth and across the nation that cases should be decided on the merits. And when it can be cured.
What standard of review do we apply to the portion of the judge's ruling dismissing with prejudice? Doesn't he get to decide that under Rule 41?
Well, there's a controversy about that. And the controversy about that is whether it's an abuse of discretion standard or not. I would suggest to this court that you need to be careful on this, because it is de novo, but it also, all we could appeal from was his order. And the United States Supreme Court, in a case called Singleton versus Wolf, and then Exxon Shipping versus Baker, said you really, yes, you can look at the at other factors, but you should concentrate on what the judge was in front of him or her and what was they used for the decision. Because otherwise, in just a fundamental fairness or almost a due process argument, the appellant doesn't have a full and fair opportunity to litigate it. So the rule with prejudice is simple. Is there a possibility that you can allege a fact that will cure the defect? If there is, with prejudice is an abuse, even under an abuse of discretion. You've got to give the appellants the appellants a shot. And that's all we were asking for. All we were asking for is if you don't find that this is sufficient, please grant us leave to amend. And we can, and I make that representation to you, that it would be one paragraph as to where the shares are owned. The parties are proper. I will represent that to the court. There are no new parties that need to be brought in, and we can add the language that the shares are in the estate of George MACKOUL and Jeanette MACKOUL, period.
Okay. All right, thank you very much for your argument. We're going to turn now first to Attorney Cavaney for 12 minutes, correct?
Yes, Your Honor. And thank you. And good morning, Justice Vuono, Justice Meade, and Justice Grant. May it please the court, Donald Cavaney for the defendants, appellees Charles Barbara, Janet Barbara, and Sedler Corporation. And the appeal as it relates to Sedler wasn't mentioned at all and wasn't briefed by the appellants. And I do think I'd like to hit that issue right out of the gate. The judgment that did enter in favor of Sedler Corporation, as well as BEECHWOOD INN and the Barbars. While they filed a notice of appeal, they did not brief the dismissal of Sedler Corporation. So I believe they've waived that, Your Honor, and that issue should, they've waived it. So they can't, and they haven't talked about it this morning. So that issue should be waived. With respect to the issue of stock ownership, Your Honor, I came in 2019 in this case, but in 2018, I certainly did go back to the pleadings. And the issue of stock ownership was raised in that 2018 opposition to one of the original motions to amend. And that's what led Judge Wren, who's the same judge who decided this case, to give a warning to say, this may be subject to a 12B or a Rule 56 motion sometime down the road. So absolutely stock ownership was raised back in 2018, and it was never addressed. With respect to the third amended complaint, they filed that third amended complaint. It supersedes the prior amended complaints. And even listening to my brother this morning, there's still uncertainty, still confusion as to who owns the stock. Paragraph 45 clearly states that by operation of law, when George MACKOUL died, it went to Jeanette. But at the hearing in August, Judge Wren, and this is at page 81 of the record appendix, was in essence summarizing everything from the third amended complaint and said, well, then they passed to your wife, Jeanette. And Attorney MACKOUL said, no, they don't, Your Honor. So the verified amended complaint at paragraph 45 says it's Jeanette MACKOUL owns the shares. At the hearing in August, he says, no, she doesn't own the shares. And then he goes into it's being held in trust by one of the estates. And then today it's, well, both estates own the shares. So they still don't have it. They still haven't identified who is the owner of the shares. And Your Honor, we moved for motion to dismiss in June. We raised this issue in those papers. It was not addressed. He ignored the standing issue that was raised in the motion to dismiss and addressed it for the first time at the August hearing when he was prompted by Judge Wren. So he had an opportunity in June in response to the motion to dismiss to seek further leave to amend. He had an opportunity at the end of walking out of court in August of 2020 to seek further relief from the court to file an further amended complaint. He didn't do it. He's been on notice for a long time that shareholder derivative claims, you've got to maintain ownership and establish ownership of shares throughout the case. He's failed to do it, and he's failed to do it for 4 years. And so Judge Wren was entirely appropriate for him to dismiss on our first argument that they had not established standing because they had not established stock ownership at the time the complaint was filed. And again, I would argue that continues through today. They still have not identified who owns those shares. And so again, because they have not, they had every opportunity to seek leave to amend. They didn't. Now is not the time in January of 2022 to seek further relief from this court to amend. So Judge Wren, I think, was correct. The motion to dismiss should have been allowed and should have been allowed with prejudice. And I also, again, this wasn't really addressed in this morning, but the direct versus derivative claim, they argue that there's some direct claims in here. And again, the complaint is straightforward. It is a derivative claim. If you look for the prayers of relief on pages 41, 42, and 52 of the record appendix, he is requesting relief on behalf of the shareholders, including the plaintiffs. The entire verified third amended complaint is a derivative claim, and there are no direct claims at all in the third amended complaint. I do think that even if this court finds that standing was established, which again I don't believe they have established it with respect to stock ownership, I do think it's entirely appropriate for this court to consider the alternative arguments that we made in Superior Court that would also justify a dismissal of this case, especially the failure to comply with 7.42 of the Business Corporations Act and Rule 23.1 as it relates to the shareholder derivative demand letter. It's faulty on multiple grounds, and by their failure to comply with 7.42 and 23.1, they've also failed to establish standing to assert these claims. But before I jump there, I don't know if there's any questions for me as to the standing issue as it relates to stock ownership. If there are, I'm certainly.
Don't worry, we're not shy. If we have questions, we'll interrupt you and ask them. So you can keep going. Thank you.
Thank you. And so as it relates to the first alternative argument, 7.42 and 23.1 are real clear as to what steps must be taken, the prerequisites that must occur before you file a shareholder derivative lawsuit. And I did file a motion to amend the appendix to include the actual shareholder letter, the demand letter that we received, in our response to that. And it's referenced in paragraphs 168 and 169 of the complaint. But the ask was for two actions. Please show us evidence of stock ownership, and please let us look at the records. And there's no dispute that Attorney Cedar responded on behalf of Beechwood to that demand and said, here's a copy of the stock certificate showing your 25 shares. and we're going to make 10 years of records available to you. And you can come in and let us know when you want to come in. We'll make them available to you. And they've never responded to that. And so because they haven't done that, they have not complied with 23.1 or 7.42 in order to establish standing to pursue a derivative claim. They've absolutely failed to comply with both of those, with the statutory provision and the rule. And on top of that, another failure with respect to the shareholder derivative demand is the content of the demand. Again, asking for two items. It did not assert that Charles Barbara or Janet Barbara breached any fiduciary duties to anyone. It asked for documents, and the corporation accepted that demand and said, "We will. Here's the stock certificate, and we'll make the records available to you." And so, because the corporation accepted the demand, the plaintiffs are not permitted to file a shareholder derivative claim. So that is another reason, even if they do establish stock ownership, that the complaint should have been dismissed with prejudice. And with respect to the with prejudice, because I'm down to my last 20 seconds here, I do think it's an abuse of discretion standard. And I do think when you are dealing with a standing issue, in this particular case, judge decided also on 12b6 because an element of the claim of a shareholder derivative case was to establish standing, and he didn't do it. So 12b6 was appropriate. Dismissal with prejudice was appropriate.
I think you've covered all your points, but I want to let you know that I think you still have a few more minutes because the clock was set at 12 minutes, not 15.
Oh.
So that's how we do it. So if you were, if you thought that you were going into the other person, your colleague's time, I don't think that was the case.
I did. I confess I did not look at the clock when it started. So I think I've addressed the third argument. I'll rest on my papers on the third argument with respect to the statute of limitations. I really just wanted to establish the two standing arguments: lack of stock ownership and failure to comply with 7.42 and 23.1, the shareholder demand letter requirement.
Okay, thank you. I think we have that, and I'll see if there's any questions.
Sorry, do you want to say anything about what degree of discretion we need to accord to the judge to decide to make the dismissal with prejudice?
Yeah, I do believe it's an abuse of discretion standard to be applied, Your Honor, and I say that because, again, one of the elements of this claim is establishing standards. So he did get into the elements. It is an adjudication on the merits, and therefore I do think abuse of discretion is the appropriate standard to apply.
Okay. Thank you very much for your argument. We'll reset the clock. We'll have 3 minutes. Attorney Von Nostrand, the floor is yours.
Thank you very much. May it please the court. As I'd indicated, I represent the defendant Beechwood Inn Incorporated in this case. In the limited time that I have available, I do not intend to retrace the ground covered by Mr. Caveney, and intend to limit my remarks to two discrete arguments made by the plaintiff in their appeal. The first being the status of the corporation as a moving party, and the second, which I'll take up first in light of Justice Grant's question, the with prejudice nature of the dismissal. With respect to that, Attorney Boscovich had mentioned that there's some controversy. I do not believe there's controversy. What there is a lack of precedent in Massachusetts with respect to that standard. But we've cited a Fifth Circuit opinion, Schiller versus Physicians Resource Group, which is on all fours with this case. In fact, one of the virtually the sole issue addressed in that case was the question of what standard should be applied, and applied an abuse of discretion standard. And I would encourage the court to adopt that standard in the specific circumstances of this case, where there has been several attempts to amend the complaint and a number of opportunities provided by Judge Wren at the hearing to give the plaintiffs the opportunity to try to correct the issue. In support of that abuse of discretion standard, I would point to the importance of a trial court of managing its own docket and deciding when enough is enough, when a plaintiff has had enough bites at the apple. And I would encourage the court to apply the abuse of discretion standard. And in applying that standard, it's clear that Judge Wren, undoubtedly frustrated by the plaintiff's ability to correct the issue of ownership at the time of the hearing, granted the dismissal with prejudice. Turning briefly to the other issue, discrete issue as far as the corporation as a moving party, while it's true we did not initially file a motion to dismiss, when the other defendants did, we orally moved to join that motion at the time of the hearing, which is clearly articulated in the transcript that's part of the record. And Judge Wren clearly granted that oral motion to join in that in the motion to dismiss.
All right. Well, I see that you calculated your argument perfectly. Time is up right now, right when you finished. 1-0070, Craig Brown and others versus Jeffrey Entin. Is that how you pronounce the your client's name?
Yes.
Yes, that's correct. All right. Jeffrey Entin is trustee of the Entin Inter Vivos Trust and another. On this a Zoom platform, sometimes we have some brief technical difficulties. If we do, just be patient. We'll take care of them quickly, and no one will lose any time as a result. I want to remind you both, there's 15 minutes to present your argument, and there is no rebuttal. And I'm going to conclude by introducing the panel to you. I'm joined today by Justice William Meade, Justice Marguerite Grant, and my name is Ariane Vuono. So Attorney Stiles, you represent the appellant. You may begin.
Thank you very much, and may it please the court. I'm Attorney Ethan Stiles. I represent the Entins in this case, the appellants, and we are here today because the trial judge in this case made errors of law in misinterpreting the deed and errors in fact in finding support for that interpretation. Now, the deed in this language was undisputed as to the northern and eastern boundaries of the Browns land, but as to the western and southern boundaries, it was hotly disputed. And we believe that the judge ignored the by-calls made in that deed in order to come to a result that relied squarely on acreage, even though acreage is rarely considered determinative of a boundaries of a property as defined in a deed. Now, in this particular case, the western and the southern boundaries are where we start with the problems. Now, the western boundary, as found by the trial judge, seems to rewrite the deed to something that doesn't exist, that didn't exist. Namely, that the land that was referenced on the western side was referenced as a boundary to the land of Franklin Phillips, where
would the monument call on the western boundary take priority over the abutter call?
I believe the two are synonymous because it says on the west by a woodland formerly of Franklin Phillips by a wall. So essentially, I believe that the two are synonymous. So I don't think there's any clear priority of one or the other. But the evidence did show, I would argue, that there was the remnants of a wall at the western boundary in between on that straddled Franklin Phillips lands on both sides. So on one side you had pasture land, on the other side you had woodland, and then there was a small strip of land, and then you had land of another person that Franklin Phillips never owned. So we start there, but the plaintiff surveyor gave Mr. Brown that land, that small strip of land, but he misread the. We had to misinterpret the deed to do that. And then you go south, you get to the southern boundary, and you ignore the evidence of the rock wall. And the evidence was pretty clear there that there was at one time the remnants that there was a wall there. Now the judge said
on Staples' survey there was a stone wall where Staples placed the southern boundary. part of the way across the southern boundary, and then he continued in a line down to Jerome Street along the southern boundary, right?
Yes, although it should be noted to be clear that the stone wall begins at Jerome Street and goes westward for a distance, and then there is nothing there. But Mr. State, except for what was noted as a fence, Mr. Brown's fence that Mr. Brown put up, that there was no wall. But the wall that was called for in that deed was quite a distance north of the wall that was never there. Now on the south it reads, by Woodlot, formerly of Franklin Phillips, by a wall, and by land of Charles Phillips. Now the only wall in that area at that time would have been the land by Charles Phillips. That was just the short stone wall I mentioned. Now the southern stone wall, which I suggest to you, defines the southern boundary of the Browns' land, and essentially completes the shape of that turns into a pipe. Was the subject of a situation where the judge found that he didn't need any evidence to tell himself that there was a wall there.
Do you have a case that says that the existence of or non-existence of a stone wall is beyond the ken of an average juror or fact finder?
I believe I did cite to a case in my brief, Your Honor, close to that issue. So there is a case. I'm not sure if I can find the name of it now, but I know I cited to a case on that issue.
What do you say about the barn? The foundation of the barn and the Silvera's property that came out of the plaintiff's chain of title? That was an interesting point, because there was the evidence of the barn, which Mr. Staples somehow didn't find in 2010, but nonetheless in 2017, when Mr. Brown found it, and he found plenty of artifacts to suggest that this was a barn from Franklin Phillips's time. But anyway, other than that, I don't. The judge addressed that maybe once, but I don't think the judge really relied on the location of the barn as to the property line. I think it was more an issue of getting the 6.5 acres that the plaintiffs claimed, and supposedly the deed showed. But acres is a trouble. I'm sorry. But if the probate documents to do with Franklin Phillips's estate refer to buildings plural, doesn't that mean that the barn that's within the disputed area was part of what was contained in the 1913 deed?
Well, there are two problems with that, because first, land in buildings is a fairly generic term as given in a probate document. Actually, the second problem, of course, that's extrinsic evidence and not included in the deed that was actually in there. Or if it wasn't, it was in a generic sense. And third, the barn very well have been in disuse by that time. So the substance of land and buildings, I don't think doesn't shed much light on the intent of the grantor in this case. And area is a problematic issue because who can tell you the difference between 4 acres and 5 acres, or 3 acres and 6 acres? You sweep your hand over a field and say, I'm selling this big field, I think it's about 6 acres. Who are you to tell otherwise, unless you have surveying practice? And we even see that Mr. Franklin Phillips, when he was alive, had issues with being able to mortgage out the acreages that he actually owned versus what he claimed. And also in the probate records is also more acres than actually what he owned. And even in the plot plan that Mr. Brown had, that still miscalculated the acres, and they had the benefit of measurements. Anyway, so reliance on acres is a troublesome concern, and I think one that this case squarely implements. Now, as going back to what I was going to talk about, what the judge had to say, he said something to the effect of, I know a rock wall when I see it, and perhaps referencing a somewhat more famous formulation. But nonetheless, I would suggest in this particular case, this is not a case of where you know it when you see it, when we're talking about the remnants of a rock wall, not the existence of a current wall, because no one said, today, as they tried the case in 2019, there's a stone wall there. That was not the defendant's case, and it could have been very well construed by the trial judge otherwise. But what the parties were trying to prove or disprove was whether there was once a wall there, and whether that was the actual southern boundary, And the evidence on that clearly favors the defendants, because even the plaintiff's expert, the surveyor, said, I think it's a fence. The rock wall expert said, I can't rule out, I don't think it's a wall, I think it's a stone road, but I can't rule it out without excavating it. And that is what the LiDAR evidence came the closest to. Because if you actually look at the LiDAR panels, that's Exhibit 149, you can actually see the shadows, the same shadows being shown at the plaintiff's undisputed northern boundary, which was a rock wall. That was not disputed, that Mr. Brown's northern boundary is a rock wall. You can see that. And then you can see two lines immediately south adjacent to it. I think they call it scars in the transcript. And we would suggest that those scars show what an excavation would ultimately show, is that the closest thing to it is that, namely, that there is similar depressions in the ground from heavy things that have been there for a long period of time and cast the same kind of shadows. The sort of thing that LiDAR, which is in relative new science, but that's the sort of thing it showed. So when the judge pretty much ignored that to say, I don't think there's a wall there, it's really not, that doesn't really address the issues the parties were trying to contend, and brought experts to bear on the question. So ultimately, we have a situation where convenience has dictated what this boundary is according to the Staples plan, the plaintiff surveyor, namely that you have giving Mr. Brown land that his predecessors never owned, and ultimately woodland to an imaginary line that was simply drawn up to get back to the street, because you go west and south and you have to go back east, an imaginary line, and that line doesn't make much sense. That doesn't make any sense, because if you're talking about woodlot on the fence that's there was wood both north and south of that fence. So that's not a very good idea. So essentially, it's almost as if that they are redrafting the deed to say from land of other owner east by a line and by a rock wall by Charles Phillips land back to Jerome Street, and that's obviously something you can't do. So essentially, it gets to the point where the error is combined, so that Mr. Brown got something that was far more than what he bought, what he thought he was buying, and perhaps most importantly, what the actual evidence of the usage of the land showed. Because you can see both.
I have a question for you before you run out of time about Elmer Robinson. What is the specific type of conduct that Elmer Robinson did in regular response to a repeated situation?
Well, Mr. Dyer indicated, the defendant surveyor indicated that he knew Elmer Robinson personally because the ages coincided, and that he talked about certain issues regarding the surveying practices in his deed, and he referred to. Hold on, make sure I get.
But without Robinson's survey, how was there proof of what his specific conduct was?
Because Mr. Dyer said, I've seen Elmer Robinson's deeds. Elmer Robinson was known in the area. We surveyors know what an Elmer Robinson deed is. We know what he
But
was
isn't
good at,
that
what he was bad at.
reputation or character evidence as opposed to specific habit?
No, I don't. And I think it's habit, because ultimately we're not saying, was Elmer Robinson a slump? Well, you make the inference, Mr. Dyer's not saying Elmer Robinson was a bad surveyor, he was a sloppy surveyor. He said, no, Elmer Robinson didn't do distances very well because he didn't have a survey crew. That was what he said. But he said, but it wasn't all negative. But yeah, he was talking about what specifically Elmer Robinson would or would not do in his surveys, and his experience with those, Elmer Robinson's surveys informed his reading of the deed. And I would suggest that is actually.
He knew from when Dyer was 11 years old and Robinson was an old man.
I believe
they knew each other.
Yes, I mean, because I believe Mr. Dyer did say that he was apprenticing with his father, who was also a surveyor. So there was some overlap. And of course, also don't forget that Mr. Dyer had decades of experience after that as well, reviewing deeds by Elmer Robinson and perhaps surveys as well. So I think I covered, let me just briefly cover argument 3 before my time is expired. Now that is the issue of Mr. George Tabor, who was the Browns' prior predecessor in title and who was found by Mr. Entin after the findings and decision in this case. And while it may have been preferable that he was found earlier than that, nonetheless, the rule permits new evidence to be reopened within a year on good grounds. And I think the year is the cutoff for that reason. So we don't be opening up cases 20 years from now because of something that was overlooked. So and the cases look to what the evidence was what the probative value of the evidence. And that I think is the key point here, is because the evidence that was proffered indirectly suggests that the reason why there's only remnants of a stone wall rather than the stone wall is because Mr. Tabor's grandfather took the rocks from that stone wall to build his shed or his garage. And I think that is something that should have been explored, because ultimately that provides the missing link in the puzzle of what happened to the southern boundary. Why does it talk about a wall? And to the extent the judge didn't want to hear it because of so-called tactical considerations, I would suggest that, the issue, how can you make a tactical decision if you don't know what a witness may have to offer? And in this case, it was not known until Mr. Entin discovered the man, and he absolutely may have discovered before, but the courts don't require admissions. And ultimately, if the suggestion may be that there's some kind of bluff in providing an affidavit, well, that would be on Mr. Entin if that affidavit turned out to be false. So I think that would have been sufficient evidence, and the judge should have opened the case to hear from Mr. Tabor, who otherwise could not have been heard of because the case had already been closed. And with that, I will rest on the briefs. Thank you.
Okay, Attorney Stiles, thank you very much. We'll turn now to hear from Attorney Avery. Well, you need to unmute yourself. One moment.
Good afternoon. May it please the court. Ryan Avery for the appellees, Craig and Jessica Brown. I'd like to start my argument today by clarifying the standard of review regarding what I refer to as the claim in the main, that being the Entin's alleged points of error and the boundary lines adopted by the court in its judgment. As your honors know, this was a case of competing surveys, and the primary, if not sole, function of the trial judge was to make factual findings as to the location of the various monuments set forth within the plaintiff's senior conveyance, which was the 1913 Hart to Delano deed. When a boundary line is in controversy, it is a question of fact on all the evidence, including the various surveys and plans where the true line originally ran and was to be established. A court's location of disputed boundaries on the ground then is a matter of fact to be reviewed under the clearly erroneous standard. In essence, the only questions of law provided or presented by this case were, first, whether the totality of evidence supported the boundaries adopted by the Superior Court to a preponderance of the evidence, and second, whether the court correctly applied the hierarchy of priorities that case law suggests should guide, if not expressly control, the court's location of boundary lines. And the trial judge absolutely followed this hierarchy in correctly locating all of the natural and man-made monuments, describing the southern and western boundaries at issue in this appeal. Nor do the Entins claim otherwise. In fact, they've avoided discussing the hierarchy of evidentiary priorities or the plaintiff's burden of proof altogether in their briefing. Instead, they've narrowly focused on the location of a questionable abutter call within the Browns' western boundary description, as well as the fact that the wall running along the southern boundary adopted by the Superior Court does not run the entire length of the southern boundary. Neither of those facts are dispositive as a matter of law. And I'd like to spend just a moment addressing the totality of evidence favoring the Browns' claim regarding each of those boundary lines. So on the western boundary, the Superior Court located the strong New England wall, as it's described by both parties in their joint pretrial stipulation of fact. The then also located the woodland described in the deed, and therefore it found both the natural and man-made monuments marking the Browns' western boundary, which, according to the hierarchy of priorities in case law, renders deciphering that western abutter call unnecessary. In addition to that evidence, the wall and woodland fixed by the court for the western boundary begins at the Browns' undisputed northern boundary wall and runs to a stone wall that marks part of the Browns' southern boundary, as well as the woodlot of cut and stacked wood testified to by Mr. Staples. So the western boundary found by the court gives coherence to the parcel. It links to other boundaries, with the final bound being Jerome Street to the east. With respect to the southern boundary, the boundary line fixed by the court runs partially along a wall. It runs partially along a woodlot in the same general area, and then it runs partially along land owned by Charles Phillips in 1913. And as you know, the court found that the southern boundary proposed by the defendants did not run along a wall anywhere. And it's undisputed that it did not run anywhere along the land owned by Charles Phillips in 1913. So the Superior Court found all of the monuments describing the Browns' southern boundary within their senior conveyance. And in addition to that, it fixed the boundary along barn remains, presumably of Franklin Phillips, discovered by Mr. Brown and testified to at trial with photographic evidence. And in addition to that, finally, the boundaries as a whole create a parcel of 6.63 acres, which approximates the 6.5 acres referenced in the senior conveyance. So, Your Honors, our argument would be that this evidence accounts for not only a preponderance of the evidence, but clear and convincing evidence of correct boundary lines. Despite that overabundance of evidence, the Entins have used that questionable western abutter call to essentially manufacture what are otherwise nonsensical western and southern boundary lines that don't conform to any of the natural or man-made monuments referenced within the senior conveyance, nor to the abutter call of Charles Phillips referenced along the southern boundary line. These discrepancies were emphasized at trial and in post-trial motions, as well as in the court's decisions on same. Yet the Entins have pressed on with their unmeritorious claims as to the boundaries. And that has led us, as you know, to request that this court not only affirm the judgment of the Superior Court, but allow my clients leave to file a petition for fees and costs. And beyond the sheer weight of the evidence and the authority cited in our brief and discussed in the post-trial briefings, we submit that the Entin's appeal is frivolous because it fails to present any novel issues of law or policy considerations that would warrant reappraisal of settled law. In addition, the appeal misrepresents several significant holdings of the trial court and advances several misleading arguments. For example, the testimony of the Entin's experts was not uncontradicted or unimpeached. And in fact, each of the Entin's experts openly acknowledged severe deficiencies in their own work product. Their LiDAR expert admitted that his work included or superimposed fake sun shadowing on the LiDAR map. Mr. Dyer admitted that he failed to find this alleged southern boundary wall in his first survey of the property. And Mr. Joyce, the title expert, admitted that several of the prior conveyances prior to the plaintiff's senior conveyance didn't mention stone walls along that southern boundary eventually drawn by Otis Dyer. The Entins have also alleged acquiescence of my clients to their proposed boundary lines, despite the fact that the parties stipulated to the dismissal of the adverse possession claim before trial. They've suggested on appeal that the Entin's failure to contact George Tabor was inadvertent, but in the post-trial briefings, it's clear that that decision was purposeful and tactical. They've also suggested on appeal, without any record support that Mr. Tabor was uncomfortable signing an affidavit, and that's why Mr. Entin had to submit the affidavit. And they've also repeated the suggestion that a still never before seen survey from Elmer Robinson not only exists, but has some bearing in this case. So for all of those reasons, Your Honor, we request that the Superior Court judgment be affirmed and the appellees be given leave to submit a motion for fees and costs. And with that, I'm happy to rest on my brief, but I'm happy to also answer any questions about the other issues, which we believe have either been waived or not properly preserved for appeal.
All right, just one moment. I'll check with the panel to see if they have any additional questions or any follow-up questions. I see none. So I want to thank you both very much for your argument today and for your briefs. So we'll take the